Thank you so much for inviting me here. It's really a pleasure to be with such a good group of people who actually really know, data. They understand research tools, and I often, when I speak at other events, I don't normally have that luxury of being in front of such a knowledgeable crowd. Today, I want to talk a little bit about. Wait, is this thing on? Let's just do a quick mic test. Test. Oh, a little bit.
I'm told it should, by default, stay on.
You're okay. There, it's on. It's on. We're good. So today I want to talk about data analytics in the law and in the library. I'm going to kind of go through where data analytics came from. Many of you are probably very familiar with it. Some of you, maybe it's just an initial, a new topic for you. Where it is today and where I believe it's going to be going. And then in addition, not just where it's going, but what's the place of the law library with respect to data analytics? Because I think it should be very central. Thank you very much, Greg, for that amazing introduction. To recap it, though, I actually started off as an engineer. That's actually that was my initial career before I even went into law. I worked as a systems engineer down in Santa Barbara. I came up to San Francisco quite a bit, but I was much more of a central coaster. Then I went to law school and became a patent attorney. And during my nights and weekends, I started building stuff, all sorts of different types of things. And some of those things became bigger things. Some of them I started using in my practice from day to day. And actually, speaking of the library, my office at the firm was right next to the library directly. I could just yell out and talk to librarians. I don't know if you know Lucy Chrissy Gonzalez, but she was one of the lead initial testers of docket alarm. I showed it to her all the time, asked her questions. We had long lunch conversations. And she gets some credit for this, definitely. So I worked actually doing this on my nights and weekends, and then in 2015 I left. Last year in 2018 it was acquired by Fastcase, which many of you are familiar with. It's a large case law research platform. But I've been out in the space for 6 years, litigation analytics. And while that's not as long, that's not that long of a time for litigation analytics, that is quite a long time. Litigation analytics is a relatively new field. It's starting to mature now. But it hasn't been around for more than 6, 7, 8 years. So I think, like all good keynote talks, you can't just launch right into it. You got to kind of go around. So I'm going to start off with an analogy, and that's travel. All right, and then we're going to bring it into litigation analytics soon. Okay, so first, back in the day, and I'm not talking about back in the day in the 60s or 70s. Back like 500 years ago, travel was risky, expensive, and it was rare, all right? It was something that could be very dangerous. Going from point A, from one town to another, you normally had to hire a guide. You could get mugged along the way. You could get lost along the way. And often your guideposts were something like this, all right? Not very easy to read, not very accurate, and you were mostly relying on the intuition of the guide, on the knowledge of the guide bringing you from point A to point B. All right, this is kind of, in many ways, the kind of first wave of travel. It was based on intuition, it was based on knowledge, it was based on experience. All right, and that was kind of the first wave. What changed after this? Obviously, after the printing press came along, there were maps. All right, and maps changed everything. All of a sudden, you can go from point A to point B, relying on something that was published, that was easily accessible. It democratized the way that we got from places from point A to point B. Travel became much more reliable. It became much easier, it became cheaper, and actually it allowed people to travel much more often. It actually increased the amount of commerce and the amount of travel that was in the world at the time. However, it wasn't all that good, all right? Because maps were not perfect. This is a map of the world in 1491, all right? This is a very famous map when it was produced, and it's not known exactly if Christopher Columbus used this map to get to the Atlantic. I mean, he didn't, because there's no, they didn't even know where it was to get across the Atlantic. But at the time, this was the best map that they had. And even if Christopher Columbus didn't use this, he definitely had access to it because this was very, very widely known a map. But you can see here how inaccurate it is. I mean, you can kind of make out the blob that is, Europe and Asia. Africa is very, very deformed, but it's in there. Australia, there's some islands in the bottom right that are Australia, that might be Australia, but they're actually not. Those are just kind of drawings that people put in there. They really didn't know. And then up in the top right, you can actually see a sliver of Japan. They knew that there was a landmass out there that was Japan. They didn't know where it was, how far it was. They knew there was a blob out there, so they got that right. But they didn't even know the direction. They just, again, aesthetically, they thought it would look nice to make it like look long. And just by luck that it kind of sort of matches kind of the elongated shape of Japan. So this is what happens. I mean, this was at the state-of-the-art technology in 1491. But we've come a long way since then. I think the epitome of like the highest level of good map technology, of published map technology, is probably the World Atlas. All right, and so when I was a kid, I had a big, beautiful atlas. Mine was actually Rand McNally, not National Geographic. But we had these big, beautiful, kind of laminated, thick, glossy page atlases, and you could just go look from page to page across the entire world. All right, and this is kind of the peak of what kind of printed map technology can bring us. And I remember as a kid, I would just look at these pages. The ones that I would be fascinated by is just the pages with the Pacific Ocean, just wide open blue. And I would just stare at these pages, and I'd zoom in. I'd love looking at these little tiny islands. All right, the ones that like Wake Island over here, and some of the Northern Mariana Islands. And I would just be staring at these like, what is going on these islands? Is there buried treasure there? Are they inhabited? Are there pirates there? I want to see. It was burning to know what was on these islands. But this actually kind of brings about the problem with all published materials in many ways. There was no way Rand McNally was going to make me a map of what was going on of Wake Island. I could call them up, or I could ask my parents, hey, Dad, I want to know what's going on in Wake Island. He'd call up Rand McNally. He's like, my kid really wants to know what's going on in Wake Island. Can you make a map for it? They're not going to do it, right? Maybe they'll pay you lip service. Okay, maybe the next edition. But they won't going to do it, because if they do it for one island, they have to do it for 50. And it's going to take too much time. They can't publish a book that way. Clearly, it was not going to work. And the reason is because right now with this mapping technology, it's really read-only, all right? Meaning the publishers give us something, and we consume it. And if you don't like it, and you want something else, you can call them up, you can ask for them, you can beg for them, you can offer to pay more money for it, but it's really, you're at their mercy, all right? And that's one of the major problems with, maps that we have. So what happened after that? Okay? I said the first wave of kind of mapping technology was intuition and experience, and the second wave, still revolutionary and great, was published mapping materials. There's another third wave that was actually coming about. And this was something I experienced first in college. Does anyone know this program? It's called Keyhole. It was this, I think, I learned about this in the early 2000s. I think this one says the image is here from 2004. But it was this really cool piece of software. You downloaded it to your computer. And it was very, very, took a lot of computing power. I remember my laptop was burning up. It crashed multiple times. But the idea was straightforward. What it did is it took images from various different maps across the world and stitched them together. And so you could see different maps, and they stitch them all together, and you can zoom in from one map to another, and then zoom out, and then pan right and left. And for the first time, I remember that when I got this thing, the first thing I did is I went to the middle of the Pacific Ocean and was looking up these islands. And it was like this itch that I was wanting to scratch for a decade was finally scratched. It was great. So you might not have heard of Keyhole, but you probably have heard of its successor. In 2006, Google bought Keyhole, and Google Maps is Keyhole today. So this is what it looks like on Google Maps, looking at these islands. I think I have here the Marshall Islands, another set of relatively tiny islands. And if you look these up in a standard atlas, this is what you'd get, right? Some mostly blue and a couple dots, all right? But the difference is with Google Maps, of course, you can zoom in, and you can see there's some shapes there, right? Zoom in further, and you can actually see that there's significant, you can actually make out what the island looks like. You can switch to a more comprehensive, to a satellite view. You can change your viewpoint of what what you're actually looking at. And you can zoom in further and see that there is actually quite a bit of civilization here. There's no more, very unlikely you're going to find buried treasure on this island. In fact, you can make out schools and airports, and actually not on this slide, you can't see the airport, but there is one not that far off the map. And actually, if this was live, we could just slide it and you can take a look at it, right? And there's some swimming pools here. So there's quite a bit of civilization. And the main difference between this map and the published atlas is that this one is read-write. Okay? This one is something we can change. Every time we do a pinch on our iPhone and zoom in on a map, we're actually we're creating a new map. We're creating a custom map. Every time we look from satellite view to terrain view to the map view, we're creating a new map. And this actually goes a lot further than just Google Maps zooming in and out. Has anyone ever used Waze? It's another kind of mapping app. All right, Waze does more than just zooming in and looking at different types of data. Zooming in, zooming out, looking at different parts of the map. It actually overlays other data on top of the map. So with Waze, this is a picture of Manhattan. What they do is they can put on traffic lights. Traffic cameras. Speed traps, construction information, all sorts of different data that can be overlaid on top of this map. And this is very much read-write. I mean, they even have a button here that says edit the map. And they actually encourage users to go in there and start changing the data and start modifying it. And when you modify the data, the idea being that when you modify the data, it gets much more rich. It's much more useful. And this goes even further. I mean, this is Waze, but which is also, I guess, a Google product, but it doesn't have to be, within these large companies. This is a really cool, animation showing you combining a map again, but with density information in New York City. So this is actually, you can see from the morning to the evening how dense different parts of New York City are. And besides being pretty hypnotic to look at, the idea here is that we're taking two different data sets and merging them together. We're actually being able to create your own data is a very, very powerful capability that has been enabled only the past few years. And it's come a long way from this. All right. So that's the analogy. Okay. Now let's bring it back to reality a little bit. All right. But just a recap here. Kind of the first wave of travel is based mainly on experience, on guides, on knowledge, on intuition. All right. The second wave is based published mapping data. All right. Basically published ways of getting from point A to point B. The third wave I see in the future, what we're headed towards now, is being able to customize and modify that maybe. Not relying strictly on the publisher, what they give you, but being able to take in some information from various sources, using our own analytical tools and being able to build something new out of it. So how does this relate to legal services? All right. Where's the data in legal services? What does this compare to a map? So legal services, much like travel, are risky, expensive, and rare. All right. You need a guide to get you to map out anywhere you're going within any legal matter. You have to hire attorneys to get there. All right. They like travel. You need it's a good experience to get you from point A to point B. But many of the questions that need to be answered in the legal space can actually be answered analytically. All right. So let's take a look at some of them. How much is my case worth? This is one of the most standard questions that is asked by every single client, no matter if you're on the defense side or on the plaintiff side. If you have a slip and fall and you want to go in and say, how much can I sue Walmart for because I slipped in their office, slipped in their store? This is the type of question you're going to ask. If you're on the defense side, it might be exactly the same question, how much are we going to have to pay? All right? Many attorneys have been relying in the past on intuition. Listen, I've seen a bunch of these cases. I think this is going to be worth $50,000 or more or less, depending on how many they've seen before. A more analytical approach, this question could be answered in a much more analytical approach by looking at all of the actual cases they've ever dealt with, counting them up, and actually giving out a real distribution of actually how much they've paid in the past. And this is not just for litigation, this is also for transactional matters. Another very standard question is this clause in this transaction standard? Very similar answers you get from experiences and hunches from attorneys, but really, there are analytical ways of answering this by looking at an entire contract database, extracting proper clauses from it, and figuring out how often those clauses appear. And it also happens in actually the litigation cost management. How much is this litigation going to cost? It's one thing to say, well, our budget is X thousand dollars per month. We think these things might take between anywhere from 6 months to 4 years. So your range is from $50,000 to $7 million. That's kind of a very typical answer. Another way of doing it is mapping out all the litigation matters that you've ever had in the past, figuring out the bell curve of how much they cost, showing them where you think that their case falls in this, and giving them a nice range, saying, listen, there's 80% of cases cost less than this amount of money, but then those 20%, they can get very, very high and cost this much. And using an analytical answer to actually answer these questions is actually very much in the realm of what we're capable of today. All right, and then actually a more standard one, and I'm going to focus on this one because this one is actually in many ways already solved by a lot of the vendors that are out there. What are the chances of winning a motion? All right, you have a motion coming up. What's the chances of actually getting this granted or denied? And let me show you that the first way of doing this is something like this: an all attorneys email saying, "Pardon the interruption. This is from Pete Pest at Big Firm LLP. I have an important hearing coming up concerning a motion to dismiss or lack of personal jurisdiction next Tuesday. Does anyone have experience with this judge or this issue generally? If so, stop by my office." Always in bold, ASAP. And I love that the THX. It's always they can't even. Well, you have to go by their office, but they can't write the A and the N and the SK. You know, it's like so. But this is pretty standard, and this is what I mean. As an attorney, I receive these all the time, and this is what this is looking for. Is it's looking for experience, and it's looking for hunches, but it's not actually looking for real data. Okay, and this last question, I think I'm going to focus on a little bit more, just because. This one is actually almost solved. If you're still doing these, if you're still answering, motion likelihood granting or denied questions without having a real data analytics system behind you, you're already behind the state of the art. And I want to actually be talking about what's coming next, not as actually what's currently happening. But like a current answer, the problem with sending out those emails is, attorneys will give you a bunch of different answers, right? Any given attorney might. I've been in front of this judge 2 or 3 times, and they might say, "Oh, he's really tough," or "He never speaks," or "He's really plaintiff friendly." They give you this intuitive information, but it's very different than pulling up a system and says, "Hey, 75% of plaintiffs do this well in front of him, defendants do that well," and you can really break it down. And I'll show you some examples of what this looks like. And actually, with that, let's just talk about analytics. So, what are these analytics? What are these analytical tools that I'm even talking about? Many of you have probably already seen these. Some of you might not have. I know I definitely recognize some faces. I know some of you definitely have seen these. But I just want to kind of go over them again, not so much to focus on like reviewing what are the different vendors that are out there, but I want to talk about how it's actually done. How is a sausage made, all right? I certainly know how it's made at my company, and I've talked a lot to other people, and I pretty much know how they're doing it too. But there's 3 main components to doing any analytics, all right? Number one, one is extracting data. Number 2 is aggregating data. Number 3 is visualizing data, all right? These are the 3 main components that are going to go into any analytics platform. And I'm going to show you how it's done for motions, all right? So first of all, what is data extraction? What do you even mean by that? What is even data in the legal space? Like what are we even extracting here? So let's just pull up a complaint, all right? This is a complaint for trademark infringement. And this is probably, I forget how long this was. Actually, it says on the top, 60-page complaint right there, right? Pulls from Pacer. So what's some data that is in this complaint? Well, the court name is a piece of data, all right? The actual complaint name itself for trademark infringement and also the other parts, unfair competition and unjust enrichment, this is all data points, all right, that we can extract. All right, there's information about the parties. The various parties are involved and their addresses and their locations. These are all data points. We extract every single piece that we can get. Further on, you get to see the different claims for relief. Extracting this information is extremely important, right? You want to pull out as much information. Each one of these, each sentence, don't think of it as an English sentence. You have to think about it as a piece of data that we can collect. All right, and even at the end, the SIG block, all this information is data. And it's not just the complaint and the underlying documents. That's obviously very important. But you also have the entire docket sheet. All right, this is a docket sheet pulled off a docket alarm. You can get the same thing off a Pacer. But there's a lot of information on here. This is the judges, the cause of action. There's dates information, right? There's whether things are granted in part or denied in part. There's a ton of information. You can even see here. You can see the response and the reply and the order that actually resulted in the outcome in this case. So you can actually track the different parts of the motion and how they're interlinked with each other. These are all data points, and you have to extract them. And what you do is once you extract all this information, you kind of create a model of what you're trying to analyze. And so for litigation analytics, this would be different if we're talking about contract or transactional law. But for litigation analytics, the model is the case, all right? The lawsuit. So in the case, you'll have a complaint, you have papers, you have hearing. There's lots of facts, judicial opinions, outcomes. All this stuff we try to kind of put together in a single package, all right? And if you were doing analysis of contracts, you'd maybe have the contract package. If you're doing an analysis of litigation spend, maybe you'd have the matter package, okay? And lots of data points within them. And then the next step, once you have this nice package, you repeat this. You do it over and over. You do it for thousands of cases, millions of cases. And this is what we call data aggregation. So what we'll do is we'll take all of our cases, and then we start comparing all the data points within them, extracting them along the same line, and then you can build legal intelligence out of this. And then the fun part, the part that most of us interact with, we normally don't actually see behind it, like as a librarian, as a user of these systems, we don't normally see the extraction and the aggregation. We tend to see the visualization, right? The pretty parts, which is actually really fun because it's visual. We can interact with it. Data extraction, normalization, that can be pretty tough. So here's just a screenshot of the types of analytics that Docularm can produce. Here we're analyzing a particular type of motion. If you've never seen this before, you should definitely start reading up because this is out there and it's not just us who are doing this. We're looking, you can very clearly see that this particular motion gets granted 67% of the time. You can see it month to month over time, how often it gets granted. The green is granted, the yellow is partially granted, the red is denied. You can see how long it takes. All right, so this is what we would use for motion analytics. For judge analytics, you can do the same thing, but instead of extracting it motion by motion, you can extract it motion by motion, then subdivide it by judge. So you can see some judges that have lots of cases, and then over here in this column, you can see how often they actually grant that particular motion for each judge. So you can actually start doing apples to apples comparisons of judges. All right, same thing with parties. It's not just judges that we're analyzing. We want to look at parties and see how aggressive certain parties are, how often they win, how often they lose. Same sort of thing. So we can see how often, this is in a particular jurisdiction here, when you can see Apple and Samsung are very, very heavily used here, and you can very active here, and you can see how often they win in various motion types as well. And these are just examples, but we're going to go, there's many, many more. Here's a case flow diagram, all right? So showing you what we're doing here is we're not just extracting, win or loss. We're extracting what's happening at every stage of the trial. And so you can actually see how many cases go from point A to point B to point C to point D within a single trial. All right, so I've been just showing docket alarm slides, but it's not just docket alarm. And actually, there's a lot of folks right outside there that are doing the same. You all might be familiar with Lex Machina, the Lexis product. It's also showing it's very, very similar types of information. Here we're looking, again, these are judge analytics showing you how many cases. I'm sorry, this is at the top is just showing you how many cases that get filed every year. On the right-hand side, you see how many cases are in front of a particular judge. And the bottom, you get to see how it's broken up at different areas of law. All right, with ways of basically slicing and dicing this data. And that's in Delaware Chancery. Galvalytics, who has a booth right outside, should definitely take a look. Here, they're actually showing you LA County courts and showing you how we're looking at a particular judge right now. And you can see how likely it is that a judge would kind of rule for a plaintiff or rule for defendant. And you can see this little needle here. I guess this right here is the average. So on average, judges rule kind of mostly for plaintiffs, I guess. But this judge tends to rule much more for defendants than average. So it's a very nice visual way of pulling out this type of data. But behind the scenes, I'm certain they are doing extraction and aggregation, just like we are. This is also Westlaw Edge. They're actually the newcomer to the block, but they have a really nice product, absolutely a beautiful product. Even though they're new, they kind of came out fighting. So here we're analyzing also, again, the different types of motions, how often they're granted, and it's very hard to read in the slide, but they also have a time to rule, how long it takes. So the same sort of information. If you're doing any sort of motion analytics, there's plenty of tools that are out there already. And you should have access to them, or someone in your firm should have access to them. And it's not just motion analytics, because motion analytics kind of tell you how often motions get granted or denied. There's also other types of ways of looking at the same data. And so here's what's called an interactive timeline. This is something that's put out by Fastcase. And here we're showing how citations within a court opinion are linked to one another. And from this, you can actually tell which citations are the most relevant to a particular set of cases and which aren't. It's a way of looking at a citation network rather than looking at grant or denial rates of a particular type of motion. And the same sort of thing actually is in Lexis Context, which is relatively a recent addition. Here we're showing basically how, for a particular judge, we're showing how often they cite to certain types of cases. I'm showing the relationships between the judge and their citations. So it's not just granted or denied. There's a lot of different types of data points you can be pulling out of this type of data from citations and from much more. And I want to also follow up here just with analytics that this might be relatively new to the commercial, legal industry or to private law firm industry, but it is not new at all to academia. In fact, academics have been working in an area called empirical legal studies for decades, and there's conferences about them, and they do exactly the same sort of analysis. They look through cases by hand, one by one. They've been doing this since the 60s, and they didn't necessarily have a very high-tech tools to do this. Even today, I speak to them, and they still rely on an army of student assistants, and they go by hand, one by one, case by case by case, a giant Excel spreadsheet, marking down what happened in each case, and then using, that is the extraction. Then the aggregation is basically, pulling all that stuff together in a single row in Excel, or column rather. And then the visualization is basically just using Excel charts, or sending it to their graphics team inside the school. And actually, I had a picture of an empirical legal study, but it's gotten lost. It's all right. All right, so hopefully that last section might have been somewhat familiar to you. I really hope it was, because this has already been out for quite some time. But let's talk about the risks. Let's talk about the scary parts about relying on these analytics. And the scary parts, what's problematic about the analytics that we have today. Okay, because that what I've showed you just before is not even the state of the art. This is stuff that's out there, all right? It's widely available. So there are risks involved when we rely heavily on data. Okay, like this. Christopher Columbus, relying on this map would never really make it to America, right? It could be because the data is inaccurate or incomplete, like this, right? Or just completely wrong. This is a map of California. Spanish explorers, they just thought it was a big island, and maybe it will be one day if there's a big enough earthquake, right? But anyway, or it can just also be just kind of very similar to what I experienced, which is like you just can't see it. It's not even incorrect. There's nothing incorrect about this map, but we just can't zoom in far enough to actually get what we want, right? That's one of the major problems with a lot of the analytics providers. They only show you certain slices of the data, but you want another slice that's they're not even available. However, I think actually one of the most serious risks of our current analytics system is the risk of misinterpretation. All right, this car ended up in the dip because someone was following Google Maps. All right, and they thought that a ferry line was a bridge. And they didn't even look to see that they were going into the water, all right? This is a real story, all right? So they misinterpreted the data they were seeing on advanced Google Maps where they can zoom in, zoom out, and they thought a ferry line was a bridge. So this is a very serious problem, and it's funny, actually, what's actually pretty serious here too, you can see there's some scuba guy who's like trying to rescue them, I guess. But this actually happens, and it has already happened in litigation analytics. And I'll tell you a story, all right? So we released our litigation analytics in, I think it was early 2016 or late 2015. I can't quite remember. And we did it for the PTO, all right? So we released litigation analytics for the Patent Trial Appeal Board. It's an agency it's a court within the USPTO agency, right? And our numbers didn't match up with their numbers. And I was just shocked. Okay, they put out some published numbers. Our numbers were 10 or 15% off. And I was like, holy crap, what did we do wrong? We must have messed something up entirely, all right? And I looked and we recounted all of our data, and we just went over everything all over again, and we couldn't find any problems with it. So then we started digging into what they were doing. And like, how is it we're off by 15%? It was basically like 15 points. Like, it was a big difference. And so we started digging into their methodology. And what's funny is after we came to the conclusion, we were not wrong, and they weren't wrong. It was just they were putting out statistics that were very misleading. And I'm going to go into a little bit of detail here just to kind of point out, I'm going to talk on the high level, but kind of point out kind of what the gist is. But the end result is actually we did write this paper, and it got published, and they changed their methodology and actually fixed it, so that they don't even do this anymore. But this was actually this is a very common mistake. It's one of the most common things I actually see in litigation analytics that can actually it's not that it's inaccurate, it's that it can lead to misleading results. When you only look at analytics for completed cases, if there's a litigation that's going on and you want to actually analyze like litigations, but you say, okay, I don't want to analyze active litigations, I only want to analyze completed litigations, all right? It's a very standard thing to do. It's like, I don't want to see what's going on in the midst of the middle of the case, I just want to look at completed litigations. If you do that, you're going to really skew your statistics, and let me show you why. Take a very simple motion to dismiss, okay? A motion to dismiss. A motion to dismiss can either get granted or it can get denied, all right? If it gets granted, what's going to happen is the case immediately gets closed, right? It gets dismissed, and then immediately when it gets granted, it goes into your statistics pile, okay? So the day it gets granted, that thing gets into your statistics, and you just counted it as one motion to dismiss got granted, all right? But what if it gets denied? Then you have to go to trial and discovery, and it could take another 2 or 3 years. And then only after that case ends does it actually get counted inside of your analytics. So when a motion to dismiss gets granted, you immediately count it, but when it gets denied, you have to wait 2 years before you get counted. So basically, what you're doing is you're over-counting the granted motion to dismiss, and you're undercounting the denied ones. And this is a relatively straightforward way that you can take an accurate analysis and create very, very skewed results. Okay, so this is, I kind of went down in the weeds. I kind of want to back up a little bit more and talk about some more fun stuff. And where does a law library fit into this? And I'm going to entitle this From Sentinels to Data Scientists. Okay, let's see where we're going to go. Let's talk. We're going to go back in time again. We're not going to go all the way to the 1400s. Let's go to the 1800s. All right. So the 1800s, in the early 1800s at least, law librarians were largely inventory managers. Okay, they really were in charge of making sure that the books, how many books were in their library, making sure that they weren't stolen. There was definitely some research applications, but it was not nearly like what it was today. 2 major things happened in the late 1800s that really changed the game for law librarians. And I think they're arguably interrelated. One is Harvard Law School started changing the way it teaches courses. They started applying the case law teaching methodology, which required students to look a lot at case law much more rigorously. And as a result, they needed much better research tools for researching case law. And it just so happens, right around the same time that this was happening, this guy started his business. I don't know if you know John West, but this is back in the day when your character was measured by the size of your sideburns. But he got his start right in the 1870s. 1880s, excuse me. And then he first started off with a standard publishing company, kind of publishing treatises and normal law books. But then he's like, I'm sick of this. I'm sick of all these different newspapers and reporters publishing kind of random case laws, random case law publications. Normally, normal newspapers, if they didn't have enough, if they had too much space, they would just kind of fill it up with case law reports, because that was kind of their filler, and it was just kind of a constant mess. So in 1887, after moving into his new office, John topped it off by announcing an audacious plan to catalog every single case according to what he called the American Digest classification system. This is the beginning of Westlaw. It's the beginning of modern research professionals in the library. All right, this really, really changed the game because everybody became, you were no longer just a sentinel standing over books. You were the gatekeeper to finding the information that was buried within those books. And that was really the 20th century. This is 1960s UVA, and it was a bustling hive of research activity. You did your work. The law library became, it's to the physicist, the chemist is a laboratory, the law library is to the law student, right? Or to the lawyer even. This is where your work was actually done. But even at this time, and actually, just continuing on, even as books became less prevalent, Boolean search terms, there's plenty of other technology for law librarians to actually stay on top to stay on top of, to stay as research professionals forward. But even John West, actually, just to tell you a little bit of history of John West. So he started the West Company, right, the West Publishing Company. It's unclear, he either got kicked out or he quit. But regardless, it was not on good terms, all right? And he spent the next few years starting another publishing company. And he started writing articles trashing the West Digest system, okay? It was amazing. And I just love this. This guy, this is a quote, 1909, all right? There's a false theory that cases and propositions dealing with changing conditions may be made to fit a rigid classification. The classification of today will be as inadequate in the future as the classification of the past is at this time. This is John West's words about 5 or 6, 10 years after he left Westlaw. All right, less than 10 years. This is in 1909, 110 years ago. What is he actually arguing about right now? Okay, what is he arguing? He's saying that this is when a publisher gives you these digests, when a publisher tells you how to analyze the law, you're stuck in their way. It's a read-only system. We need a way to actually have the digest, to have our research tools be much more customized, be able to build them and actually be able to know how they're understood. And we need a read-write system. Okay, and that's really why. He has this. Yeah, we need a read-write system that's actually much more malleable, that law librarians can actually use and change as they see fit. And this goes on. He actually suggested basically having a internal. He had a way of dealing with this, but basically it was kind of customized law digests for certain practice areas and certain firms, and law librarians themselves can make their own digests. But he was really speaking about a read-write methodology. I say he was 110 years ahead of his time. All right, he was a pretty impressive guy. And so this actually brings us to today. The 21st century, if the 19th century was mostly inventory management, the 20th century was really to becoming research professionals, I think the 21st century for law librarians are going to be real data scientists. All right, understanding data, understanding how it interlinks together. It's going to be a change. It's going to be a little bit scary, but it's going to keep the profession alive and really, really healthy. I think it's for the best. So what are these final opportunities? Let's talk about some concrete things that maybe we can start looking at. Where is this future with customized data, with changing data? All right. The opportunity is that if we can start wrangling this data, if we can start interacting with it, if we can start using it, we can actually mitigate a lot of the risks that accompany it. Right? If we understand how the data is extracted and how it's aggregated, we can understand how it can be misinterpreted. We can understand the gaps in it. And that's really where law librarians have to actually be looking. They have to start questioning where the data is coming from. They have to know how it's being made up. If there are gaps in it, it doesn't necessarily mean throw it away. It might mean it could be useful, but you just have to know that there's gaps there and then be able to work around those gaps. So one of the areas I see is basically user-defined analytics. All right, being able to build your own analytics from the raw data. And that's kind of like taking raw data from street densities and then kind of putting it on top of other raw data that you see like on a map or on Google Maps, kind of combining those two. So how do we do this actually? The old school way of doing this is with Excel, and it still works. All right, so being able to use Excel is very, very important. Being able to extract data from various sources, extracting docket data is one way, extracting expert witness data, putting it into a giant Excel document, slicing and dicing it and building really nice graphs is really, really helpful. And it actually can be used, and law librarians should get used to doing this. If Excel is Excel doesn't really span very much beyond 10,000 rows or so. And then there's other tools like Tableau, which is more or less Excel on crack. It can do millions and millions of rows. So you can analyze much, much larger pieces of, much larger data sets, and it has very, very nice ways of combining different data sets. Then there's tools like the AI Sandbox, which is a Fastcase product, which basically takes different data sets from various, and some of these are competitors, that take different data sets and merge them together so you can start slicing and dicing them in your own way. But it doesn't have to be from us. There's being able to understand APIs and understand how different data is kind of interlinked with other data can be very, very helpful. This is just a short list of some of the APIs that are available. But there's so much legal data that's actually out there already from commercial vendors, that's out there publicly. Being able to pull that data in, being able to understand what's in it, and being able to manipulate it is very, very important. And you know what that's going to mean? I'm sorry, it's going to come to this. I'm going to have to say it, but it might mean we actually have to learn a little bit of how to code. All right? We might be taking a coding class. Is not going to be the worst thing. Maybe that should be required in a Master's of Library Science degree. All right? You don't have to be an expert programmer, but it actually does make a lot of sense to actually learn this. And there are so many online, free of courses that you can take, and relatively inexpensive local live ones, where you can actually start doing this and start wrangling the data. Short of that, I don't want to plug my stuff too much, but there are other ways of working with this data that does not require a coding degree. There are really good understanding of coding. There's tools that basically, like the analytics workbench, that allow you to do custom analysis on state court analytics or on particular types of litigation data. And actually, in some ways, Tableau kind of does the same thing. You can download all of your firm's billing data, for example, and make very, very nice charts and slice and dice that in very, very interesting ways. Nope. There we go. I'm going to end with this one. Really, J.R.R. Tolkien, you all know him from those books. He had built this whole universe, right? And he recognized that he couldn't even build this universe at all without a map. His books always start off with a big, beautiful map showing kind of the universe that he's going to kind of dive into. And I don't just see, J.R.R. Tolkien says you need to have the map. But the question is, who's going to be the map maker? Right? I really do see law librarians as the map makers for the litigation space. It should not be vendors. It should not be DocAlarm or LexisNexis or any of them. It should be you folks. And you should be able to wrangle this data. You should be able to understand it. And you should be able to get real answers from it. That's all. Thank you.